ahead and get started. I'll just open with a word of prayer. God, we thank you again for the gift of today. We thank you for our capacity to understand and to empathize, and we pray not only for the courage of our convictions, but the compassion that flows from our convictions. In Jesus' name, amen. Okay, so just as a 10,000-foot recap, what we've been doing this week, and I've been very thankful for John Walton's Bible Hour because it's provided a framework for how I understand what we're doing better, and that is we're really trying to understand our own cultural river as it comes to very divisive, controversial issues. And so in all the topics we've covered so far, sanctity of life and race and the new atheism, and today with religious liberty, tomorrow with Phil's going to do faith and science, the point is not on agreements, right? So much of our society is focused on, well, do you agree or disagree? Are you going to click like on this tweet or on this Facebook post? Are you going to share this? Are you with this group? Are you against this group? Figure out where you stand and align yourself. You haven't heard me say anything about whether I agree with this or disagree here or here. That's not the point. And not that I mind disagreeing. I'm an attorney. I don't mind disagreeing. I actually enjoy it. But our focus this week is on understanding, right? When our focus is on agree, disagree, that sort of acts as a gate to relationship. Understanding is a path that can bring us into relationship. Agreement or disagreement may or may not come later. But that's not the point. The point is relationship. And so one of the things that we've been trying to do this week is to broaden the picture from today's hot button disputes to see how that arises in context. So, the fact that Roe versus Wade or the Obergefell case, those don't just drop out of the sky. Those are formed over many decades of changes in our legal, political systems and culture. And so when the Women's March in Washington does not allow pro-life groups, that doesn't just come out of nowhere. That's a long history. It doesn't mean we agree with that decision, but it means we have to understand what the backstory is. Or, when you see, in the Twin Cities, as I talked about, when you see Black Lives Matter shut down I-94, that doesn't just come out of nowhere. Right? And one thing we didn't talk about yesterday, I-94, one reason that's such a symbolic place for protest is when they decided to link St. Paul and Minneapolis with an interstate, they built I-94 directly through the Rondo neighborhood. And the Rondo neighborhood was the historical black community in the Twin Cities, where black professionals lived, black-owned businesses were. More than 600 black homeowners and 300 businesses were displaced by I-94. Rondo Avenue, which was the namesake of the neighborhood, did not exist anymore. And so, to engage what's happening now, it's helpful to know the history of Rondo in the Twin Cities. That's what we're trying to do, is just deepen and expand the understanding. So today, one thing on the slides, there's a few more slides up here. I'll bring more handouts tomorrow. The handout you have now for today, I've changed that some, because I went back yesterday afternoon and changed a few things, added a few slides, so make sure you make some notes, because some things have been revised. You don't have the wrong handout, I just made some last minute changes to it. So let me address one point from Tuesday's talk on race. And I had some great questions afterwards, some great comments. One thing I just wanted to flag, and we don't have to spend a lot of time on this, is it ever okay for Christians to break the law? Put differently, are Black Lives Matter protesters already stepping outside of the zone in which Christians can support them by virtue of the fact that they're breaking the law. I would say in the Christian tradition, it's very hard to support the point that Christians should never break the law. Whether you're looking back from Daniel, Shadrach, Meshach, and Abednego, Dietrich Bonhoeffer, who tried to assassinate Hitler and broke many laws of his society, to Martin Luther King Jr., there's a long tradition of civil disobedience. Now, for Christians, how you disobey the law and why you disobey the law, your intention to disobey the law, matters a lot. So Martin Luther King Jr., who, by the way, we talked about natural law on Monday. Natural law is very unpopular because it's mostly associated with arguments about same-sex marriage or abortion, etc. Really, the last great publicly accepted, well, in some circles, publicly accepted, full-throated advocate of the natural law was Martin Luther King Jr. His whole ministry was based on the natural law, saying that an unjust law is no law at all, and your loyalty, your allegiance goes to God's law, but you have to disobey the law openly, lovingly, and with a willingness to accept the consequences. You're bringing attention to the injustice through your disobedience. You're not trying to get away with anything. So Martin Luther King Jr., when he disobeyed the law, like marching without a permit, because his group was never going to be getting a permit to march, he would willingly be arrested and go willingly in handcuffs because he was trying to bring attention to that injustice. So the fact, whether it's Black Lives Matter or any other current protest group, the unrest we see in our streets, the fact of disobeying the law is not the end of the conversation for Christians. We go deeper because as much respect as we owe our legal system, it's not our ultimate source of loyalty. Okay, so just keep that in mind as we talk about all these, and this is a little bit of a segue into what we're talking about now. Is the shopkeeper's ultimate loyalty to the law, or is there something higher that might cause them to disobey the law? Okay? So, religious liberty. How did we get here? How did it, religious liberty used to be viewed as this, the noble dissident in society who's protected in their right to worship God as they see fit. Today, religious liberty is often, in many circles, viewed as a thin guise for outright bigotry, right? That Christians like religious liberty because we want to be able to keep oppressing people, right? So the words that are often associated with Christians, with evangelicals, with traditional Christians, lean much more toward bigotry, discrimination, exclusion, and so the cause of religious liberty has been taken down that road as well. So here's what I'm going to do today. I'm going to give you a bunch of background on religious liberty, because again, if we're going to engage on legal issues, we can't just say, well, I like this, I don't like this. I like this, I don't like it. No, there are principles. There's a framework that we have to utilize to understand what the issues are and why courts and why decision makers come out the way they do. Okay? So I'm going to give you a bunch of background, and then we're going to have a discussion about some current hot topics and see how that background plays in. Okay? All right, let's start. Is America a Christian nation? Well, it depends what you mean. Do we mean that there's been a divinely inspired, inherent U.S. Constitution? I hope that's not what anybody means, right? We do not have a divinely inspired, inherent U.S. Constitution unless, for example, blacks count as 3/5 of a person. And there's a whole laundry list of things where we would say, no, absolutely not inherent. Genesis 3 did not take a 5-year hiatus during the framing of the Constitution. Okay? Do we mean that God likes America best? Is that what we mean by a Christian nation? I don't think so. At least I haven't seen much evidence in Scripture to suggest that that's the God that we worship. That there's a majority Christian? Yes. And that's true. That's descriptively true. The question is, what if that changes? Does the Christian nature of the nation, is it just a function of demographics? Do we mean we're a Christian nation because our system of government is based on Christian principles. Sort of. You can read some of the separation of powers. We talked a little bit about this on Monday, how we've structured our government based on a particular view of the human person that is certainly shaped by a Christian heritage. I think the bigger question, though, is why is it important? Why do we care? Right? So when we refer to the U.S. as a Christian nation, what message are you trying to convey? Are you trying to invoke a larger set of principles to which we should continually aspire? Are you trying to communicate sort of an in-group status to signal that others are really not part of this in-group? Are there clear policy determinations that flow from being a Christian nation? I don't know. I don't have a clear answer to that, but when you hear phrases revolving around Christian nation, ask, what's the purpose? Why do we care? What are we trying to do? What are we fighting for in being a Christian nation? Okay? So is America a Christian nation? Did the founders intend for us to be a Christian nation? We're not. We could obviously spend 3 full weeks talking about the history of the country at the time of the framing. There was a Treaty of Tripoli in the late 1700s. The government of the United States of America is not in any sense founded on the Christian religion, which is true. It was not founded on the Christian religion. There are principles that were shaped by the Christian heritage. Adams, Jefferson, Franklin were probably not Orthodox Christians. It was unclear whether Washington was. Witherspoon, John Jay, and Sam Adams pretty clearly were Orthodox Christians. Here's, I think, the key point. All agreed that religion was important for public morality. It doesn't mean they were Christians. It doesn't mean they were trying to found a Christian nation. It doesn't mean that they meant certain substantive principles needed to flow from our Christian identity as a nation. It meant that religion was important for public morality. That's relevant to what we're talking about today with religious liberty. Okay? Religious liberty in the U.S. colonies, again, remember what I've said before, do not romanticize the past. Our history of religious liberty is spotty at best. Okay? In New England at the time of the founding and before the founding, New England, other than Rhode Island, was mostly Puritans or Congregationalists. Each town was essentially a congregation. Massachusetts banished Baptists in 1644 and they hanged Quakers. There was grassroots intolerance, right? Because each town was like a congregation. In Virginia, the Church of England was established as the church. The state colony expelled Puritan ministers and some Catholics. There was top-down intolerance, right? It wasn't that Congregationalist approach. It was top-down. It was official policy, Church of England. New Jersey and New York, there was a tremendous amount of religious toleration, mainly because there was a tremendous amount of religious diversity right from the beginning. And then Rhode Island, founded by Roger Williams. Maryland, founded by and for Catholics. Pennsylvania and Delaware, founded by and for Quakers. And then Carolina generally was founded for dissenters. Right? So there's a patchwork of approaches to religious liberty, but we need to avoid the mistake of saying America has always been committed to the most robust forms of religious liberty, and now we just started losing it in the last 20 years. Our history is very spotty. Okay, why is religious liberty important? There's two leading schools of thought on this. One is that religious liberty solves a political problem. Because the conflict between church and state threatened the stability and security of the government, and so we need to keep religion out of government. Okay? It solves the political problem. Religion screws up government. That was John Locke, that was Thomas Jefferson. The opposite side of the coin is religious liberty solves a religious problem. It's the overreaching state that interferes with the vitality of religion and hinders the spread of the gospel. We need to keep government out of religion. So one side says, no, government can only flourish with religion out of the picture. The other side says religion can only flourish with government out of the picture. And the latter position was Baptists and Methodists. And You know, it's one reason Baptists have traditionally been very strong on religious liberty is because that's in their DNA. Right? Keep religion flourishing by keeping government out of religion. And these aren't necessarily inconsistent. There can be elements of truth in both. Why is religious liberty important? Now, if you want to go beyond that, you know, Christians often try to articulate why they should care particularly about religious liberty beyond those two leading theories. Some will say, well, it's because the Bible explains that God created us in free will, and religious liberty honors that free will. I think that's true. It's not very convincing to non-Christians, to non-believers. Right? The divine revelation is not persuasive. You could say you must ground the argument for religious liberty in observable truth about human beings. We desire to know truth. We desire the good. Right? Religious liberty honors human nature. Everyone, has an innate desire for truth and for the good. That truth cannot be imposed. It has to be freely sought and owned for ourselves. And religious liberty allows us to do that. And why is this all important? It's because if religious liberty is viewed as a thin guise for bigotry, we have to have better answers as to why religious liberty matters. That's why I'm spending a little time going through this. So the notion that you cannot coerce someone to embrace truth or embrace the good, doing so turns them into hypocrites. There has to be freely chosen truth, the freely chosen good. Okay, let's go into some particulars about constitutional history. One thing you hear all the time about religious liberty is you hear this wall of separation. It's a wall of separation. You're challenging the wall of separation. I bet if you surveyed most Americans, they would say the wall of separation is a leading clause in the Constitution. It's not in the Constitution. The wall of separation didn't appear in Supreme Court cases till the 20th century. It was a phrase used by Thomas Jefferson in a letter to the Danbury Baptist Association. Baptists were objecting to the fact that Connecticut had established the Congregational Church as the official state church. So separation that was referred to by Jefferson was meant to ensure that the state refrained from establishing one official church. That's the wall of separation he was talking about. 2 days after writing the letter, Jefferson attended a church service held in the House of Representatives, which suggests that he didn't mean this sort of absolute wall of separation. There can be no intermingling of religion and state. That's not what he meant. Now that's often how it's used today, but we have to be historically accurate. The wall of separation was not in the Constitution. It was used by Jefferson to object to an official state establishment of a church. Okay? There's limited power to that image, and now it has been taken to mean an absolute separation between church and state. Okay, so what does the First Amendment say? Again, we can't just pull things out of the air for how we want religious liberty to operate. We have to, as a society committed to the rule of law, follow the principles and apply the principles and the provisions set forth in our governing documents. So, First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. That's the language. The earlier draft of the First Amendment said rights of conscience. Then it was changed to exercise of religion. Why does that change matter? Well, it suggests a few things. One, exercise is not just conscience. Exercise is conduct. You exercise your religion. It's your behavior. It's not just your conscience, what you believe. Conscience might just be individual, not institution, right? A church or an organization can exercise religion. It's a little bit dicier to say that the church or organization has a conscience. So when you switch from conscience to exercise of religion, you make it institutional. Conscience also is not limited to religion. I think we could all see that. You can have something violates your conscience even if you're not a religious believer at all. Right? You have a conscience. So substituting religion for conscience might suggest that religion is special, right? We didn't go with conscience. And this is consistent with the understanding at the time of two kingdoms theology, which we won't get into, but at the time of the framing, certainly religion was viewed as special. There's no question on that. Okay, now we'll get a little bit more technical, so bear with me. First, the Establishment Clause. That part of the First Amendment that prohibits both states and Congress from establishing religion. You cannot establish religion. That is interpreted to mean that the government cannot favor or disfavor a particular religion over another. More recently, it's come to be interpreted, and more controversially, as providing that the state can't favor religion over non-religion. Okay? Establishment Clause basically means state can't play favorites when it comes to religion. The Lemon Test, it's called the Lemon Test because it came from a case called Lemon versus Kurtzman. That's what's used for analyzing the law under the Establishment Clause. So there's 3 questions. I will not test you on these at the end, but just so you can run through this 3-question sequence when you hear disputes about religious liberty. So the 3 questions courts are supposed to ask. Does the law have a valid secular purpose? Right? So let's say the state of Iowa passes a law tomorrow that says, we're concerned about the decline in our morality. Every citizen of Iowa must take communion at least once a month. Valid secular purpose? No. No? State of Iowa says we are concerned about the extent to which kids in the inner cities are not getting a strong education, and so we're going to establish a program where we will let them use taxpayer funds to attend Catholic schools, which have been very effective in the inner cities. And people say, wait a second, you're advancing religious education. Is there a valid secular purpose to that? Absolutely. Absolutely. They're trying to improve the educational outcomes for those kids, right? But then it gets to, is the law's primary effect to advance or inhibit religion? You can see how lawyers can argue about this all day, right? Is a program that lets kids use taxpayer funds to go to a Catholic school if the public schools are failing in their neighborhood, is that primary effect advancing or inhibiting religion? It depends. Depends. And the final question, would the law result in excessive entanglement, sorry, the lemon got a little oversized there, excessive entanglement between government and religion, excessive entanglement. So let's say that the government says, well, we're going to make sure that our school voucher program that lets kids go to religious schools in certain neighborhoods doesn't advance religion too much because we're going to, as the state, review the curriculum that the Catholic schools are teaching and make sure they're not doing too much theology. Right? Then you get the entanglement. Okay? So all 3 of these prongs matter when we're evaluating the Establishment Clause. And so part of this is, you know, the cultural river. This is the legal river. When you see a ruling from a court that you say, that is crazy. How is that a violation of the Establishment Clause? How is that not a violation of the Establishment Clause? Note that judges are not just writing on a blank slate, although sometimes it might seem they are. They have to follow this framework. And so if you know the framework, you can at least connect with the kind of rationale they're trying to employ in making their ruling. These are hard cases. Okay, so Establishment Clause disputes that we have, just what I mentioned, we have school vouchers and funding, that's always a dispute. Religious charities. Can taxpayer money go to fund religious charities? It does, but that can be controversial. Access. The Good News Club, like, can the public school school give access to a Christian after-school club for kids? The answer is usually yes, but it's controversial, especially if there seems to be a privileged position that the school gives to that Christian club that isn't given to other clubs. But you can see where the issues arise. Expression, right? 10 Commandments. If you put 10 Commandments in the courthouse, is that the government favoring religion in violation of the Establishment Clause? And that's why when you have the 10 Commandments, usually the court will say, okay, this is fine if the secular purpose is educating the citizenry about our legal history, which means you're also going to have Hammurabi's Code in there, and it's going to look more like a museum, not just a freestanding 10 Commandments. When it's just the 10 Commandments, that looks an awful lot like you are affirming the truth claims of the 10 Commandments as a religious source of truth. That lacks the secular purpose, and that advances religion. Okay? Teacher-led prayers in school. Same thing. Graduation prayers. That gets tricky, right? Is the graduation prayer really just the free expression of the student who's leading the prayer, who's choosing to express their own religious beliefs? Well, you also have a captive audience, though, that's been gathered under the official imprimatur of the school, right? That's why those cases have been so tricky. Nativity scenes, right? When the city puts up a nativity scene at Christmas, are they reflecting the holiday celebrations of the citizenry, or are they saying, this is the meaning of the holiday season? We are observing Christmas as a city. And that's why, you know, the famous case where the Supreme Court upheld this, they upheld it because in this particular city, they had the nativity scene, they had the menorah, they had Frosty the Snowman, they had Santa Claus, they had a giant inflatable Rudolph. I mean, it was an amusement park of holiday artifacts, and that was fine. That was fine. And under Lemon, you can probably see why that's fine, because that doesn't communicate the message of, this is true, this is why we celebrate Christmas. It was, we're reflecting all the citizens' holiday celebrations. Okay? This is how the Establishment Clause works. Putting under God in the pledge. Right? And so Phil talked about under God being added to the pledge during the Cold War. But if you run that through the Lemon test, you can see why it's difficult. Right? Was that for the purpose of advancing religion? Was there a valid secular purpose? You'd say, well, actually, combating the Cold War was the purpose, showing that we're not the godless communists. It's very controversial. There's something we have in the U.S. called this civic religion, this general in God we trust, where the only way it can work with courts is if we really don't mean it. Right? So in God we trust on the coins, well, it's just kind of what we say. It's just a phrase, right? Under God in the pledge, well, it's just kind of who we are. It's kind of part of our traditions. And so with how the Establishment Clause works, we have to minimize the religious meaning of our religious expressions for them to be permissible. And you understand why. Because this is the framework the Constitution and the jurisprudence under the Constitution has given us. Okay? All right, the Free Exercise Clause. That's it. There's two parts of religious liberty under the Constitution. Establishment Clause and Free Exercise Clause. Free Exercise Clause is Congress can pass no laws prohibiting the free exercise of religion. It reflects a conviction that divine authority may exist, but the government is incompetent to decide that. This is the traditional justification. We know that people act out of their sense of accountability to the divine, and the government can't figure out, or shouldn't even try to figure out, which is valid, which is invalid. So we say, you have the right to exercise your religion as you see fit. It's never been interpreted as absolute, right? You know, if there was a growth in a Mayan church in the United States that was saying, well, as part of the Mayan religious tradition, we sacrifice children. So this is part of our free exercise, so let us sacrifice children. No, that would never happen. That never has happened. There's always been limits on free exercise. Until 1990, if the law, now this is, don't zone out here, this is complicated, but this is absolutely crucial. Until 1990, if the law burdened a person's religious exercise, the government had the burden to show that it furthered a compelling government interest and was the least burdensome means of doing so. Okay, what does that mean? If the government passed a law and the effect of that law had a burden on your ability to exercise your religion, the government had to show that the law furthered a compelling government interest and it was the least burdensome means of furthering that interest. Right? That's a big burden for the government to bear. Okay? 1990, the Supreme Court, actually an opinion written by Justice Scalia, who's obviously was a friend of traditional religious conservatives, especially on many issues. This one, we don't talk about as much. The Supreme Court ruled that as long as the law is neutral and generally applicable, it does not violate the free exercise clause. Meaning, the burden that the law poses on your ability to exercise your religion is irrelevant as long as the law is neutral and generally applicable. Okay? So if you're going to say, if the state of Iowa said, you know what, alcohol causes all kinds of social problems and injuries and productivity losses, etc., family breakup, etc., we're banning all use, distribution, consumption of alcohol in the state of Iowa. The Catholics and any other group that actually uses alcohol for communion stand-up said, wait, wine is pretty important to our religious exercise. Under Smith, the courts would say, I looked at the law, it's neutral. It doesn't say we're trying to target Catholics and communion. And it's applicable to everybody. The fact that it happens to burden your exercise, it's irrelevant. So that's a big change in our law. And the legislatures have tried to address that with what are, we won't get into, called RFRA laws, Religious Freedom Restoration Acts, that have taken root to try to push back on it. But where do free exercise disputes arise? Well, back in the 1800s, the prosecution of polygamy, when Utah wanted statehood, they had to forswear the practice of polygamy. There were a lot of prosecutions, and there were famous cases brought by Mormons saying, wait a second, what happened to the free exercise of religion? How can you throw me in jail for practicing what my religion teaches in terms of polygamy? And those cases were all rejected on the grounds that there are certain boundaries that you can't go past, even with free exercise. Students forced to pledge to the flag, those are free exercise clauses. Animal sacrifice cases, which have happened in some religions, those are free exercise. Zoning cases applied to churches. The Health and Human Services contraceptive mandate, which you probably read about, heard about, forcing religious institutions to cover contraceptives for their employees. That's a free exercise case. This is recent, just to be specific. Gordon College has been taken up by their accrediting agency. Gordon College is an evangelical school out east, taken up by their accrediting agency because of their honor code that prohibits sexual relations outside marriage and prohibits homosexual practice. The accrediting body, that's an arm of the state. That's a free exercise clause. If you're going to say, as a condition of being an accredited college, you have to abandon honor code that prohibits sexual relations outside marriage, that's a free exercise case. State immigration laws that would ban the harboring, transporting, or encouraging of illegal immigrants. In that case, religious figures, Catholic bishops, and other religious figures have said, wait, are you telling me that I could go to jail if there's an illegal immigrant who needs my assistance with food or transportation or whatever? Then I'm going to have to go to jail because my religious beliefs compel me to help the person in that situation. All these are free exercise disputes. So we understand the difference between the Establishment Clause. The government cannot play favorites among religions or play favorites for religion versus no religion. Free exercise, the government can't make laws that prohibit the free exercise of religion, except if it's a neutral and generally applicable law. More recent. Okay? All right. That's the constitutional background, and I want you to have that because you can't just pick or choose what you like, what you don't like. It has to be principled, it has to proceed within this framework. Here's what I want to do now. We're going to get a little more participatory here. There is a lot of the cases today that are shaped by the Constitution, but also have to do with what our legislatures, what our city councils, what our state governments are passing in terms of laws about rights of conscience. That's a lot of where the news headlines are generated, is what rights of conscience do different workers have. So I'm going to run through some specific cases here. Until the last one I get to, all these are real cases. Okay, so in many states their abortion laws allows a minor to get an abortion without her parents' consent as long as a judge gives approval. Okay? There's in small towns especially, attorneys take turns being assigned to clients who can't otherwise afford attorneys. So this is in Tennessee. The attorney, it's his turn to take on the case that the court assigns, and in this case, it's a minor who wants an abortion. Help me get an abortion from this judge. The attorney says, I'm Catholic, I'm pro-life, I love to represent poor people, I'll help out anywhere I can, give me another case. Can't do that case. Okay? So, just by a show of hands, I'm not holding you to this, how many believe that that attorney should be able to refuse to represent a minor seeking an abortion? Raise your hand. Okay. Almost everyone. In that case, the judicial body ruled he didn't have a right to refuse. It got worked out eventually, but it was very controversial, so it was not an obvious case. But let's move to the next one. Should a government clerk who's against same-sex marriage be able to refuse to issue a marriage license to a gay couple? Okay, again, this is a circle of trust. We're not tweeting out what everybody votes. If you think that that government clerk should be able to refuse to issue the marriage license to a same-sex couple because they morally object to the practice, raise your hand. Okay. A lot fewer hands. So somebody who raised their hand for the first one and didn't for the second one, tell me why. What is the difference?
Yeah, it's the law that's what was passed, was the law, so she had to abide by the law. Okay,
she had to abide by the law. That was the law that was passed. Well, now the law also was passed that allowed a minor to seek an abortion without her parents' consent. That's the...
In that case, though, they could go to another attorney. In fact, a lot of times,
right. Exactly.
Great. Okay, so one difference is, for the attorney, you could go to the next attorney down the line. There's a marketplace of attorneys, right? If you are the county clerk and you're controlling it, it's a more direct subversion of the law, okay? That's a distinction.
You have to be an attorney, you have to sign something as a pro bono attorney that says you will take whatever case comes along.
The question is, do you have to sign something as a pro bono attorney that says you'll take whatever case comes along? I'm not aware of, in most jurisdictions, that there's something that you have to sign. Yes?
If I was a minor seeking an abortion, I wouldn't want a pro-life attorney.
Good. Excellent. Okay, another distinction is for the well-being of the customer or the client in question. If you're the county clerk, if you're dealing with the county clerk, you just say, I just want the license. I don't really care what your views are. I just want the license. With the attorney, you say, wait, you're supposed to be my champion, my advocate. I'm concerned about how effective you're going to be. And again, I'm not saying what's persuasive in these distinctions. I'm just saying there has to be distinctions. Okay, we've got a bunch of these, so we're going to just keep running through them. Should a pro-life obstetrician be able to refuse to perform abortions? If you agree with that, raise your hand. Okay? Virtually everybody. Should a pro-life obstetrician be able to refuse to learn how to perform abortions? Okay, and let's take two examples. If learning how means reading a textbook about how many people think that the pro-life obstetrician should be able to refuse to learn how to perform abortion, even if it's only by reading a textbook? That they shouldn't have to even read the textbook about performing abortion. Does that make sense? Right, so everybody else thinks that the pro-life obstetrician should be required to read the textbook about how to perform an abortion. Okay, all right? So the next one, how about learning by participating in an abortion procedure? Raise your hand if you think they should be able to refuse in that context. Okay, what's the difference?
One is actively participating in the taking of a life.
Okay, good. One is actively participating in the taking of a life. So we think, even in the realm of conscience, being exposed to information about activities we deem immoral is different than bodily participating in that activity. Okay? Good?
If you're a pro-life
That's the same thing on the abortion versus the gay marriage or same-sex marriage.
Okay. So, yeah, maybe there's a distinction with same-sex marriage too. Yes?
If you're a pro-life obstetrician, you might have to treat somebody who has complications from an abortion, so you should know what's going on.
Good. So maybe there are valid reasons to know about the procedure and know the care side of it. Okay, here's an easy one. Should a Muslim grocery store cashier be able to refuse to handle pork products? Real case in Minneapolis. So if you believe a Muslim store cashier, this was at Target's in Twin Cities, should they be able to refuse to handle any pork products in doing their work? Raise your hand if you think so. Okay? Someone who's not raising their hand and thinks there shouldn't be the right to refuse to handle pork products, and who did vote on some of these earlier ones that there should be a right to refuse, what's the difference?
Well, they shouldn't be, knowing that they cannot handle that, they shouldn't be working in a grocery store.
Right.
Okay, knowing that they can't handle pork products, they shouldn't work in a grocery store. And knowing they cannot perform abortions, they shouldn't be working in a hospital where there are pregnant women. Oh, did I go too far? Oh, okay.
But there's a difference.
There's more people who could check them out.
Right.
What?
There's more different people who could check them out. It's sort of like that first.
Okay, so maybe it's like the lawyer.
Right.
If there's other employees who can just step in. Like when you're at the grocery store and there's somebody, not that anybody here ever would buy a six-pack of beer at the grocery store, but sometimes the person who's under 21 has to step away and someone else scan the bottle of wine. Maybe it's like that. Yes.
Well, when you go to a grocery store, almost every meat product is wrapped in cellophane.
Right. So they're not officially.
Yeah, and I can't get into the theological side of whether the cellophane is enough of a barrier. I just know there were some serious objections, right?
What about a self-employed pharmacist who runs his own business versus the pharmacist who works for a corporation?
Oh, good. Right. I didn't realize that I had skipped over that. I thought that was coming later. Yeah. So let me finish up on the cashier, and then we'll come back to your point on the pharmacist since I skipped. So another reason that somebody would have not to let the Muslim cashier refuse to handle pork products. Another reason.
I think they should be able to refuse because they might refuse me on religion.
Say that again?
I think the cashiers, if you don't want to handle pork products, I think that's fine. I can go to another store and buy it. But if they take that right for me to worship, you know, it's my choice.
So the inconvenience to the customer for the Muslim cashier not handling their pork product, where you could get another employer, go to another store, is much less, I'm hearing you say, than what it represents as a threat to religious liberty in general, not allowing it. Okay, but let me hear another reason why we would not let the Muslim cashier.
Well, my understanding is the Muslim dictators are not supposed to consume pork.
You're not supposed to handle pork either. Right? Yeah, no, this is a real case. This is a real case. Other reasons not to... Okay, yes?
doesn't the employer have the right to say, these are the requirements of this job?
Right.
If you can't do these, why should I hire you?
Then you're gonna tell the physician.
Right, and so, yes, to what extent does the employer have the right to dictate the boundaries of the job? And what I want you to think about, does that extend to the hospital with pro-life obstetricians? Does that extend, you can think of the array of issues. How much deference are we going to give to the employer? Is that an absolute rule?
How much of a difference or should be applied because of that try to go the conscience to the doctor versus, I don't think cashiers have the same.
Good. Okay, so the comment is, how much comes from the Hippocratic Oath that the conscience of the doctors is implicated in a way that the cashiers might not be? So let me use that to get back to the pharmacist example, okay? Because this gets to professional status too. These have been all over the United States. Disputes where a pharmacist is handed a prescription for what's called Plan B contraception, which some pharmacists view as an abortifacient, saying that it acts post-fertilization, and so it's akin to an abortion. They will not fill that prescription, and there's been lots of legislative battles over it, etc. How many people believe that a pro-life pharmacist should be able to refuse to fill a valid prescription from a doctor for so-called emergency contraception or Plan B? Raise your hand if you think they should be able to refuse that. Okay, how many say no, they should not be able to refuse that? How many have stopped participating? Okay, so I'd like to hear from someone who says the pharmacist should not be able to refuse, but the obstetrician should be able to refuse the abortion.
How does the pharmacist know that it's not for some other purpose?
Okay, how does the pharmacist know it's not for some other purpose? Well, it comes up, right? Go ahead. Does it function the same as a birth control pill in other contexts, right? Okay, that's a great point. Here's another question that we've got to think through. How much should the state be exploring the validity of the conscientious objection, right? So if the pharmacist says, I think this functions as abortifacient. I think this is functioning post-fertilization and it's killing a life. Should the state say, well, actually, no, that's not really what it's doing, and we deny your interpretation of that event? Or this, in other cases, let's take the pork product. There's cellophane, okay? You might think it violates your conscience, but we'll put an extra layer of cellophane, it's going to be fine, right? Or does the state have to be agnostic? Now, what comes up with pharmacists, and especially with the grocery store cashier, and this gets back to Matt's comment, is most people will say, obstetrician, absolutely, they should be able to refuse to participate in abortion. Pharmacist, cashier, and what some proponents of conscience rights will say is, this isn't really about conscience, this is about professional elitism. Right? Of course the doctors can do what they want, of course the lawyers can do what they want, but you view the pharmacist as just filling the prescription, they're not as involved, and the cashier is just scanning the thing. But if your conscience is implicated, should it matter if you're the cashier or the physician? That's one way that folks try to approach these, and to push back against the distinctions.
But as an employee, you kind of have a responsibility to your employer. Like if I'm against alcohol consumption, and I get a job as a bartender, and say, sorry, I can't serve alcohol, then I've got a really easy job. But if I'm like a restaurant owner and I say, no, I don't like alcohol, I'm not going to serve alcohol in my store, then that's a...
Good. Excellent point. So the point is, how much does the professional role rely on the ability to serve a particular function and purpose? So if I applied for a job as, let's say I'm in a state with the death penalty, and I applied for the job as the state operator of the lethal injection machine, And then it came time for the first one. I said, oh, sorry, I'm against the death penalty. Can't participate. You have to accommodate. I think the response would be, well, that's the job, right? But there's a lot, you know, most are not in that category. But does the nature of the role function to put boundaries on our deference to conscience? Let me give you one more on the Muslim. This is also a real case of the Twin Cities. Muslim taxi drivers did not want to transport passengers from the airport who were carrying alcohol. Because they view that as they were facilitating the possession and consumption of alcohol. Right? How many people think a Muslim taxi driver should be able to refuse to transport a passenger carrying alcohol? A few. Okay? So, and what's the difference here?
How did they know that they were carrying it? I mean, was it openly?
Yeah, open. So they would. I don't think they were searching their baggage.
Okay.
I think it was if they came in with something from the the store, the big bottle of vodka or something, and then they would say, I can't transport.
Well, and if there's extra other taxis that get spoken.
Yeah. So if there's other taxis, maybe it's not a big deal. Okay. So the way this. Oh, go ahead. Yeah, could they put up, as long as they gave customers notice, would that be okay? So here's what happened in Minneapolis at the Minneapolis airport. The Muslim taxi drivers, and there's a lot of Somali taxi drivers there, so it's a large number of taxi drivers. They went to the airport commission and said, we really can't transport alcohol. Can we have a line that we form for passengers without alcohol? And then there's another line for passengers who are carrying alcohol. And the airport commission said, no, and if we ever find you not transporting passengers because they're carrying alcohol, you'll lose your taxi. Right, so that was a clearance. Let me give you just one more. Transgender, this one is made up, but it's based on a loosely on a real one. Should a transgender bus driver be able to refuse to drive a bus with an anti-transgender advertisement on the side of the bus? How many people say a transgender bus driver should be able to refuse to drive the bus in that situation? Okay? Let me switch it around. But the real case was, it was an evangelical Christian bus driver refusing to drive the bus that had a pro-LGBT lifestyle magazine advertisement on the side of the bus.
Oh, that's it.
I won't ask for another show of hands, because I assume it'll be the same hands. Right? So the reason I wanted to spend a few minutes running through this, if we're going to engage on religious liberty, we have to be principled. Okay? So remember when we talked about the Buck versus Bell case, and Oliver Wendell Holmes said, required sterilization, or required immunization, military draft, forced sterilization, all the same. Piece of cake. Right? If you're going to engage at that level and say Buck versus Bell was wrong and contrary to human dignity, you have to separate. Right? You have to be principled. You cannot just react to, well, I like this, I don't like this, I like this. Right? So it's the same with these conscience, and all of these have been in local or national headlines. You have to be able to have a principled, consistent approach that's not just, I like this, I don't like this. Okay? Let me give you some just bigger considerations here. Why are these disputes in the marketplace increasing? Well, we have increasing religious pluralism. We have developments in technology. We have changing moral values. We have an expanding government role. The government's involved in a lot more stuff. And so when you're regulating a lot more stuff, because remember, your rights of conscience are usually implicated in the Constitution. The Constitution only applies when it's government action. Okay? I cannot violate your constitutional rights as a private citizen. It's impossible. Only the government can. So as the government expands, there's more points of conflict. A greater focus on equality and non-discrimination is the only moral norm that can garner consensus. We don't agree on a lot, but we agree that it's important not to discriminate. And then a changing view of professional licensing. Where it used to be professional licensing was basically, are you competent to do the job? There's a lot more to it than that. Okay? Now, I want to focus sharply on a Supreme Court case that's coming this fall, but first I want to talk a little bit about the Obergefell case, which was the Supreme Court case from 2015 that mandated same-sex marriage nationwide. Okay, so I'm not going to go in detail, but I want to give you just the basics of the opinion. So, multiple same-sex couples, some of whom had been committed to each other for many, many years, brought suit against several states' ban on same-sex marriage, saying they violated the Due Process Clause and the Equal Protection Clause of the Constitution. The Supreme Court said, yes, we agree, and there were 4 basic points they made about why. Okay. First, the court said, personal choice in marriage is central to individual autonomy. Remember this theme of individual autonomy we talked about? Personal choice in marriage is central to that. They cited Loving versus Virginia. Loving versus Virginia is the case in the 60s where the Supreme Court struck down bans on interracial marriage. Okay? So they cited Loving versus Virginia and Lawrence versus Texas. Remember from Monday, Lawrence versus Texas is the case where the Supreme Court struck down a law criminalizing same-sex sodomy. Okay? Second, the right to marry supports the crucial 2-person union of marriage, saying the 2-person union is the building block of our society. Citing Griswold. Remember, Griswold is the contraceptive case where the Supreme Court said you cannot ban the use of contraceptives by married couples. The use gets into the marital bedroom, and married couples, that's a sacred bond that the government should not be intruding on their decisions whether to use contraceptives or not. So then Griswold became the basis for the Obergefell reasoning, the right to marry supports a 2-person union. Third, the right to marry safeguards the rights of child rearing, citing Pierce, which was the case that said you can't require all students to go to public schools, and Meyer, which was the case saying you can't ban parents from teaching their kids foreign languages. Okay? Remember, those were those first cases, Meyer and Pierce. That became part of the Obergefell reasoning, saying this is also about child rearing. Then last, marriage is central to our social order. Our society depends on this, citing Alexis de Tocqueville. If any of you read parts of Democracy in America, where he traveled around and made observations, 250 years ago, 230 years ago, that was the 4th part of it, right? So Obergefell was absolutely within the river of legal thought that had been emerging in our country for decades. It was an extension. Doesn't mean it was right, doesn't mean it was wrong, but it was in that river of thought. Every point the court was making, whether it was accurately and authentically and rightfully, it was centered in a case that came before it. It was just an extension. Okay. States that were objecting to the ruling said the right to marry is fundamental in our history. The right to marry a person of the same sex is not fundamental in our history. And if it's not fundamental in our history, then you can't be ruling that it's unconstitutional not to allow it. Okay? The majority says, this is the majority of the Supreme Court said, Loving versus Virginia struck down a ban on interracial marriage as violating the right to marry, even though the right to interracial marriage is not fundamental in our history. Okay? This is going to be important for religious liberty. So, the states that wanted to keep a ban on same-sex marriage said, yes, of course the right to marry is fundamental. The right to marry someone of the same sex has never been fundamental. The court says, well, the right to marry someone of an opposite race has also not been fundamental, but we still ruled it fundamental as part of the broader right to marry, right? So Loving versus Virginia leads to Obergefell. The dissent, so these are the justices on the Supreme Court who disagreed with the ruling. They said, first, the court is not a legislature. There's no right to change the definition of marriage. And then also, the previous change in interracial marriage did not change the core structure of marriage as between a man and a woman. And a ban on, the way they put it, the racial identity of participants in marriage has never been fundamental to the nature of marriage. It arose in the United States out of slavery, where they started putting bans on interracial marriage. But it's not been fundamental to our understanding of marriage. By contrast, the participants being a man and a woman has always been fundamental to our understanding of marriage in every country at every time over history. And so you can't equate the two. The majority disagreed and said, yes, that's basically the same. Okay? So, sorry. Went back a little too far. So the question is, what does it mean for religious liberty when we are viewing same-sex marriage as a constitutional right for the same reasons that interracial marriage is a constitutional right? Okay? And this didn't translate as well. I just pulled some of these from the internet, just to give you sort of the background of what the debate is operating in now. So, you know, just a few quotes. Chris Evans, who is Captain America, in 10 years we'll be ashamed that this was an issue, you know, whether gay marriage was even an issue. Jay-Z, this is no different than discriminating against blacks, it's discrimination plain and simple. George Clooney, those who oppose gay marriage will be looked on as outdated as George Wallace standing in the school steps keeping James Hood from entering the University of Alabama because he was black. I'm not offering these to say they're right, I'm not offering to say that they're wrong. I'm offering to understand the cultural river that our current religious liberty debates are occurring.
What was the vote on that?
That was 5-4, I believe. Okay, so that's the background. Now, this fall, we have Masterpiece Cake Shop case. The Supreme Court, you'll hear this in the news in the fall, the Supreme Court's already agreed to hear this, there's going to be arguments, there's going to be a ruling. A baker refused on religious grounds to create a wedding cake for a same-sex marriage. The baker had also in the past refused to create things for a party celebrating a divorce, or there's been 2 or 3 other things he refused to create because he said, this is not, I don't believe in this, right? So it was not just same-sex marriage, but he refused to create a wedding cake for the same-sex marriage. The lower court said the baker violated the anti-discrimination law. Baker said, well, applying that to me violates my rights of free speech and free exercise. And here's what we have to ask ourselves, and we're not going to have time to get into a big discussion of this, but I want you, when this comes into the news in the fall, not just think, well, I hope he wins, or I hope he loses, because that's the right thing to do. Think, okay, what's the framework you would employ? Okay, if his refusal to bake a cake for a same-sex wedding should be legal, right? You can't force him to bake that. What's the limiting principle? Should he be able to refuse to bake a cake for an interracial marriage? Should he be able to refuse a gay couple in a restaurant? Should he be able to refuse to let a gay couple buy a cake off the shelf in his store? Right? Right? Is there a difference? Bake this for me, please. Here's my custom plans. Give me a design. Versus, this is on your shelf, I just want to pay for it at the cash register. Okay? What's the limiting principle then? If his refusal should be illegal, what's the limiting principle? Should the baker be forced to provide a cake for an abusive husband's wedding? Should an African-American baker provide a cake for a KKK ceremony? Should a singer be forced to perform at a same-sex wedding? Should a pastor be required to officiate at a same-sex wedding? Right, again, you have to have principles that you can apply consistently. Judges are always worried not just about what's this case before me, but what's next? And how can I rule on this one that's going to allow me to be fair and equitable in the next one that's coming? That's what lawyers do. What are the real points of dispute? One of the things I'm trying to do this week is sort of clear away some of the confusion and just emotion and all these things and say, what are the real points of dispute? One point of dispute. How much do we care about a person acting with integrity? I think most of us say, well, yeah, we care about that. Is that an absolute value? There are an increasing number of folks who will say, we don't care about you and your ability to act with integrity if you're acting in ways that violate our core moral norms. Then we don't want you to be a person of integrity, because your integrity leads you to do bad things. Okay? So is integrity a freestanding value that we're going to protect? Should dignitary harms matter? By dignitary harms, I mean when you're, like in the pharmacist cases, a lot of the big hoo-ha around that arose in a case in downtown Chicago where a woman went in to, I think it was an Osco in downtown Chicago, to get emergency contraception pill, and the pharmacist refused to fill the prescription. There was, I think it was a Walgreens directly across the street where she could have gotten it. Was there real tangible harm to her? No. Was there a dignitary harm of being told, I disapprove of your intended use of this product? She said yes, right? So for gay couples, even in most towns, you're going to have plenty of florists or bakers who will be happy to take your money and work at your same-sex wedding. Does the fact that you were denied service itself amount to a harm that the government should try to stand on? That's a question. That's a real point of dispute, right? And then finally, is there a difference between standardized and custom goods and services? This is a narrower question. But I think most people would agree that a gay couple walking into a store, walking into a restaurant, should not be denied service based on the fact that they're a gay couple. I think most Americans and I think most Christians would readily agree with that. The tension comes when I want you to provide particular services for this ceremony that you might have a hard time not interpreting as you participating in the ceremony itself, right? That's the difference. Where's the line? Okay. Let's, any really quick questions? Yes?
I remember seeing signs in businesses that said no shoes, no shirt, no service, or we refuse the right to serve anyone. How did we get from that and business owners being able to display that? And was that always illegal? Or when did that law change that a business owner had that right?
Okay, great question. So the question is, business owners were always able to refuse service to someone, no shoes, no shirt, no service, etc. Those were not ever forbidden grounds of discrimination. Right? There was never a law saying we are going to protect people who like to go barefoot in restaurants. Right? So the question is, it's not it's not unlawful grounds to refuse service to someone not wearing a shirt. It is unlawful grounds to refuse service to someone who's African American on that one. Right? So these are all specified in legislation as discrimination grounds that are barred. That's what's changed. Let me do one more and then we're going to keep moving.
How much of this is common sense? Had these cases taken place 30 years ago, every one of those would have said, I'm going to go across the street. And then the attorneys get a hold of it. And then now...
Now easy there. We are people too.
And now you have press and stations that you never had before. You had 3 main channels, now you've got 20. And they're picking up on every single thing. It gets throughout the country, and then it blows up.
It certainly brings a lot more attention to it. So the question is, how much of this would have been common sense 30 years ago, and now every time something happens, it's a huge issue? There is some truth to that. But let me say, there's also, we are more sensitive to our past exclusions and marginalizations of vulnerable people in our society, and that is a really good thing. So what we're talking about now is, where are the boundaries, where are the tension points, and how do we navigate them? And so, yes, a lot of this would have been handled in just a more kind of low-key manner long ago, but some of those changes have been good. Like, we understand the impact our decisions and our policies make on different people, and we want to be more inclusive. That's a good thing. The question is, how far does it go? Now, let me give you one quick example of some good news in this area. What happened in Utah, and you can look up to read more about this. In Utah, which is one of the most conservative states in the country, the Church of Latter-day Saints actually reached out to the gay advocate organizations in the state and said, let's work some compromise out here. And they, together, overwhelmingly in the Utah legislature, passed this, where they banned discrimination against gays and lesbians in housing or employment. They protected rights of religious institutions to hire consistent with their mission, and they prohibited firing people based on moral or political speech outside the workplace. It didn't handle every hard question, but it handled a lot. And it was the Mormons, who are, as you may know, very socially conservative on these issues, saying, we should not be discriminating against anyone on the basis of LGBT status in the areas of housing or employment. You should not lose your job. You should not lose your housing on those grounds. We can affirm this and still maintain some protection. There was some hopeful sign.
What if the job was in the church?
The church would be able to discriminate if it was connected to the mission of the church. Yeah,
Could the baker say the mission of my business is to serve?
Yeah, so the question, could the baker say the mission of my business? The trick here, which gets us into more technical things, is the baker is a for-profit entity. It's not a religious organization. Okay, let's move on to something much less controversial. Muslims in America. And we'll just spend the last few minutes on this. As it pertains to religious liberty. Muslims today are 1% of the U.S. population, about 3.35 million. Okay, this is from a Pew survey that was just released, I think, this summer. It's very recent. The question is, do you agree that the majority of U.S. Muslims are anti-American? Yes. Overall in the U.S., 25% say yes, they're anti-American. White evangelicals say 51% say they're anti-American. Do you agree there's a natural conflict between Islam and democracy? Yes. Overall in the U.S., 44% say yes. White evangelicals say 72% say yes. I'm not saying they're right or wrong, I'm just putting this out there. The statement, this is a survey of Muslims, the statement, I am proud to be an American, 92% of U.S. Muslims say yes, they are proud to be an American. The statement, most people can get ahead with hard work, 70% of U.S. Muslims say yes. And there's a whole bunch of statements there where Muslims are reflecting a lot of what we would say are sort of core defining American values. Key one, the statement, most or all of my close friends are Muslims. In the U.S., only 36% of Muslims say that. Globally, 95% do. Now obviously that's in majority Muslim societies for the most part, so it's very wide. But one thing that is different in the U.S. than in Europe is Muslims here are much more integrated into society than in Europe, where they have really been relegated to the suburbs and major cities. Okay. Here's the question. Do Muslims deserve religious liberty? There is a movement in different state legislatures and some on the national scene that's a movement of anti-Sharia law. There are 3 types of these laws that are being proposed at different government bodies around the country. Some say courts cannot rely on Sharia in their rulings. Those violate the free exercise clause because they're infringing on someone's right to practice their religion. Let me give you an example of how Sharia arises in a court. So we've all heard about Sharia when it's interpreted in certain ways by certain societies, such as providing for the stoning of adulterers or the cutting off the hands of thieves or apostates or whatever the case. Sharia is much broader than that. Sharia is the way to the watering hole, is what it means. And it encompasses every aspect of a Muslim's life. So they're praying 5 times a day, they're fasting, they're almsgiving, things like not being able to earn interest on a loan, which requires more creative financial partnership arrangements, marriage contracts, etc. Everything arises from Sharia. So if a Muslim is banned from having Sharia applied in court, it means, for example, their business contract can't be enforced. Or the banking arrangement that they have with a bank that has an Islam-compliant financing arrangement can't be enforced. It means their marriage contract that provides for the distribution of property along this term or this term can't be enforced by the court. Okay? That's how it arises in most of these cases. So some pending laws prohibit courts from relying on any foreign laws, because you can't target Muslims specifically, because that would violate the free exercise or the Establishment Clause. So they will say you can't rely on any foreign laws. You can't enforce any contracts that invoke non-American law. Problem there, that includes Catholic canon law, and that includes contracts based on Scripture. Right? You've maybe seen Christian mediation or Christian arbitration agreements, things like that. All that gets swept up in foreign law, because that's non-American U.S. law. Right? Finally, you have some that prohibit the courts from relying on foreign laws that would violate the Constitution. And the question there is, why do we need this? Courts are already prohibited from violating the Constitution. That's why it's called the Constitution. Right? We have it. So why I'm bringing this up is, remember what I said. When we talk about religious liberty, when we talk about anything within the legal tradition, we have to operate based on principle. Okay? It can't just be, good for you, that one's not good for you, I like this, I don't like this. And so what are the principles by which we would not extend the same religious liberty to Muslims that are enjoyed by Christians or Jews or Buddhists or atheists? And people say, well, yeah, but, I heard about an honor killing that happened in New Jersey by Muslims because of Sharia law. Yes, absolutely. And in that case, the person was arrested and charged with murder. Good. Right? In America, religious liberty means we prosecute based on conduct, not based on the beliefs that motivated the conduct. Okay? So when we're talking about anti-Sharia, if you mean, yes, we should make sure that we're safeguarding and taking steps against conduct that is motivated by Sharia that's contrary to American law and ideals, absolutely. But when you hear people talking about targeting Sharia as a source of religious meaning and a way of life, be very careful, right? Because if we're going to go down the path of saying there are some religious traditions that we believe have irrational and unhealthy behaviors that are motivated by them, and we need to stamp out those underlying beliefs from the public square and our legal system and our political system. Do you think there's anybody who would think the same about traditional Christianity? Right? So remember what I said. When judges are making a ruling on the facts before them, they're also thinking about what's coming next. As Christians engaged in the legal sphere and the culture, you can't just say, well, this troubles me, so let's do something about it. You've also got to be thinking, what comes next? Okay? It's not just self-interest, it's also, and if you want to see more about this. Russell Moore, who's the head of the Ethics and Religious Liberty Commission for the Southern Baptist Convention, gives a stirring speech about why religious liberty means religious liberty for all, including Muslims, that it has to be across the board. Yes?
Well, you say we only punish behavior. What about hate crime laws? We're not punishing behavior.
Yeah, we could have a whole session on hate crime laws, right? And that's why hate crime laws are so controversial. Is I would say this, we have to be very careful, including for hate crime laws. It takes us down a very tricky path if the source and motivation of the crime provides an enhanced punishment. Right? And that's a very simplistic statement on a complicated thing, because intent does matter, but for hate crime laws, that's why a lot of folks oppose them, is we traditionally focus on the conduct and the consequences of the conduct. So let me add a couple things here as we wrap up. When we think about religious liberty as Christians, is our reaction to specific religious liberty disputes driven more by principle or self-interest? If it's principle, whom are you willing to include in liberty's circle of protection? If it's just Christians and just this particular set of beliefs, it doesn't sound very principled.
Just a quick comment on that. It can work the other way too, in the sense that Christians want legal rulings to reflect or to conform to what they consider biblical ideas. What you've demonstrated to us is that legal rulings are often based on individual autonomy. And the fact is, the Bible does not guarantee, protect, or even value individual autonomy. So we want to have the Bible's input, but yet the very basis on which the legal rulings are made is not something that's inherently biblical.
Good, excellent. I have a hard time paraphrasing John Walton, but the basic is that we're already countercultural in terms of a biblical worldview in the legal system, not because of any particular issue on marriage or abortion or something. I mean, that can all be part of it too, but because, as we've seen, our legal tradition is really based on the autonomy of the individual and the right to make decisions for yourself. Not that that's intrinsically wrong, it's just that's not really the biblical understanding of how we order our pursuit of the right and the good. Okay. So second consideration, if you're building relationships across the religious liberty divide, assume the society decides that believing in God is like believing in the Easter Bunny. What's the most effective argument at that point? Why should your non-believing neighbors care? It was easy to talk about religious liberty when everybody has this understanding that we're accountable to God, and we just might disagree about what that accountability requires. As we move into a society where it's more common that we're not considering ourselves accountable to God, what's the argument for religious liberty? They're there, but we just have to be thoughtful about it. Is religion different than conscience? So if an atheist is morally opposed to war, should he be treated any differently than a Christian pacifist when it comes to the military draft? Right? It's something we've got to think about. Is religion special? And then finally, we have to again recognize, to borrow John's cultural river motif, that we are swimming upstream. Those who are skeptical of religious liberty are shaped by powerful cultural currents, as we are. Individual autonomy in the past, we have seen secured through strong anti-discrimination norms. Right? So we're at a cultural moment where we took a very long time to learn lessons about racial oppression and respond through the Civil Rights Act of the 1960s, which for the most part I think people would support, to dismantle the Jim Crow South. And we're still in that cultural moment. And so anything that pops up on the radar screen that looks a little bit like that discrimination is going to be treated with that same template. And so when folks are opposed to religious liberty, it doesn't mean that we don't engage and strenuously advocate for religious liberty. It means that we have to understand that we're the ones going against the current. And we have to take the time to understand the reasonable fears that motivate a lot of these moves to dismantle some of our traditional understandings of religious liberty, if that makes sense. Okay? Because again, the point of all this is not just winning or persuading, it's coming alongside and entering into relationship. Okay? That's a very quick overview of religious liberty, and we're out of time. And Phil, do you want to give a quick plug?
What? Tomorrow, no handouts.
Are we going to tolerate this again? No handouts?
Part of my religious conviction. Handouts under Sharia law. I want to talk about faith and science, and are they at war? Have they always been at war? Are we encouraging the war to continue? Do we like the war? Is there really a war between faith and science? And if we have a little more time, I have some thoughts about the local church and how the local church should interact with an increasingly post-Christian culture. River. It's all about
Awesome. Okay, and I know some people have questions. I'll be up around here, happy to answer questions or talk more. Thanks for coming. See you tomorrow.